Hello and welcome to this episode of Inside the Courtroom, the Senzo Meyiwa murder trial. I'm Mnisi. The trial wrapped on a somber note for the year. This as Tulani Mgomezulu, the lawyer for accused number one, passed away on Tuesday following an illness. And this prompted an early adjournment until next year, as his client now has to find a new lawyer. Before this, though, Advocate Mshololo, the lawyer for accused number 5, was still tearing into Brigadier Bongani Gininda's evidence, testing the reliability of the state's case against her client, Fisoguhle Ntuli. The week kicked off with Advocate Zandile Mshololo picking up on the evidence by Constable Senzo Zungu, who placed all 5 accused at the Phosphorus hostel hours before Senzo Meyiwa was murdered. Zungu said accused number 5, Fisoguhle Ntuli, was also part of the festivities that were taking place at the hostel, having arrived with a grey polo.
Around 9 p.m. on the very same day, I noticed Mnisi Mafika, open bracket, Sandy Sontanzi, close bracket, and Nkani, open bracket, Fisoguhle Zungu, Ntuli, walking after each other to Gwabeni's bedroom, coming from outside. I stood up and followed them as I was suspicious of the manner in which they entered the house. I could see there was something wrong. I found Gwabeni in the bedroom as I was approaching the bedroom. I could hear Gwabeni saying, "There comes Babo Mncane," and someone switched off the light. I saw Mnisi giving Gwabeni a 38 special firearm and Nkani giving Gwabeni a 9mm firearm. I asked them why they are having firearms on their hands and asked them where they are coming from. No one responded. I then took the 38 special firearm from Gwabeni's hand and looked at it. I asked Gwabeni if it was not the same firearm which he has said he threw away in the river after shooting Sinako with it.
And before we read the rest of the paragraph, I have a question there regarding the line which says, "I saw Mnisi giving Gwabeni a 38 special firearm and Nkani giving Gwabeni a 9mm firearm." My question to you, Brigadier, is about the 9mm firearm that was given by Nkani to Gwabeni. Did you discuss the issue of this firearm with Gwabeni in your investigation of this case, or when you were dealing with these witnesses?
My Lord, you will see that this affidavit was disposed last year. Gwabeni's affidavit was obtained in 2020. So Gwabeni came first, and the issues that we discussed with him are contained in his statement. So Constable Zungu's statement of his recollection of what happened on that day came a year later. I mean, almost, 2020 to 2023, 3 years later, my Lord.
According to Zungu, Gwabeni is his nephew who had invited him to the hostel that day. Gininda has told the court that Gwabeni's statement is among those that revealed that Zungu was present at the hostel, despite him not having revealed this to Gininda during their initial engagements in 2019.
What led you to speak to Gwabeni first before you received the statement?
It was investigations, my Lord, after the name came up during the course of the investigations.
Is it also correct that you interviewed the author of the statement in 2019, which is Constable Zungu?
I wouldn't call it an interview, my Lord. I would call it an engagement. As I've said, he came to the National Commissioner's office saying he's got information. That was the initial call about the death of the deceased. Subsequent to that, we met, then he refers to the father. So it was not, I didn't have anything to interview him on. I was more receiving information from him. That's how it was, all the way until we met his father on the 17th of November 2019, my Lord.
In those engagements between yourselves and Constable Zungu, did he mention that he saw Nkani giving Gwabeni a 9mm firearm in 2019?
No, my Lord. As I've said earlier, the first engagement was him having gone to the office of the National Commissioner saying he's got information about the death of the deceased. Subsequent to that, I met him. After I met him, my lord, the name of the father came up. Hence, then there was this endeavor to find the father, which eventually happened on the 17th of November 2019. So the information he was bringing was insofar as what his father told him, and that affidavit was then obtained on the 17th of November 2019, my lord.
Okay, so in a nutshell, Brigadier, if I'm understanding your answer, when you first met with the Constable Zungu, he never mentioned to you that he saw Ngani giving Kwabini the firearm. Am I correct to understand it like that?
No, it was the issue of the father witnessing a commotion in the homelands, and then where the names of accused 1 and 2 being mentioned as being involved in this matter, my lord.
Gininda has previously told the court that Constable Senzo Zungu first came to the picture in 2019 when he visited the office of the then National Police Commissioner, Kelly Khumalo, to inform them that his father, Absalom Zungu, had information about the killing of Senzo Meyiwa. Later that year, Absalom Zungu allegedly deposed a statement that implicated accused number 1 and 2. Important to note that Gininda has also told the court that he took over the Meyiwa case in 2018.
How many times did you interview Constable Zungu, or did you sit in a consultation with Constable Zungu regarding the incident that took place in this case? The information that he wanted to bring forward to you about the suspects and about the commission of the case?
No, like I said, my lord, it happened once. He went to the office of the National Commissioner. That was the first time. We spoke in between in trying to find out whether he was able to convince his father. So those occasions were a number of times, I can't recall, but they were telephonically. Then when I lost contact of the number that he was using, then I phoned General Shabane, as I've said, my lord, earlier, towards the end of 2019. And then initially the meeting was then arranged for the 12th of November 2019 for us to meet him with Brigadier Perumal. That meeting didn't take place. Then it was then shifted to the 13th of November 2019 where we now met him. So that would have been the second time as a follow-up of the first meeting. Thereafter, the third meeting then took place on the 17th of November when he brought his father, where the statement was then taken from Absalom Zungu.
In all of your communication, engagement, consultation, interview with Constable Zungu regarding this case, you did not take down any statements from him. Is that correct?
Which part? Because if you look at the statement that the Advocate Mchololo referred me to, it was commissioned by me, so I'm not so sure. So to say no statement was taken, the statement was taken from Constable Zungu on the 31st of May 2023, my lord.
I mean, Colonel, before this date, this statement was taken last year. I am saying, but you started communicating with this witness from 2019. And my question is, from that time, and on all occasions wherein you interviewed this witness, did you take down the statement from this witness? Before 11 May 2023, because the trial had already started, I think, by then. Yes or no, Brigadier? Just...
My lord, I think I dealt with this part and I said no because I did not see the relevance of it. He was telling me about his father, you know, it's a hearsay, he was not there. I couldn't see the relevance of it, and I dealt with this part, I think, when I was under cross-examination by Advocate Mchololo's colleague.
Mchololo questioned Gininda on the reference of the exchange of firearms contained in Zungu's statement.
After receiving this information, especially the reference to the exchange of firearms by the people who are referred to here, in front of the police officer, which is Constable Zungu, did you ask Constable Zungu if he reported this incident to the police because he had witnessed the unlawful activity? At that time, when he was in Masutu Hostel, he saw the suspects exchanging the firearms, and he was a police officer at that time. Did you ask him if he reported this matter to the police?
Yes, we did, my lord, and he said he didn't report it, and that matter was also discussed with the state, and the view was that we will look into this matter once this trial, my lord, has been finalized, because at that stage when his statement was given, the matter was already in process. In other words, it was sub judice, my lord.
Gininda says Zungu's reason for not opening a case was because he knew the accused, so he was scared for his life and that of his family. He says a decision was then taken with the prosecution that this would be dealt with at the end of this case, as the trial had already started.
Accused number 5 will tell this court that Zungu was never scared of reporting this unlawful activity. It's because Gani never exchanged any firearm with Gwabini. It never happened. That is why he did not even report it to the police.
My lord, it is clear in the statement that he viewed the accused as hitmen, and so for me, when he says he's scared, I mean, I'm not so sure who will recognize or view a person as a hitman and then at the same time not be scared of reprisal of that person acting on that. That is my view, my lord.
After the break, Advocate Mshololo continues to look into the evidence against her client, and later tributes pour in for Thulani Mngomezulu, the lawyer for accused number 1. Stay tuned. Welcome back. Now, Advocate Mshololo's cross-examination continued until Tuesday, when news of the passing of Thulani Mngomezulu threw a spanner in the works for the trial. Continuing on Zungu's statement, Mshololo turned to the part where Zungu alleges that he received threats. This is the day after his father gave a critical statement that the police believes was a breakthrough in the case.
Did you ask Constable Zungu if he reported this matter to the police because he was being pointed out by the firearm by the person whom he was able to identify as Nkazimulo Ntuli?
My lord, so when this incident happened, he did phone me then on the 18th to inform me of such, because it was just a day after he brought his father to our office for the obtaining of this father's statement. And I asked him then, my lord, I advised him to go and open a case at the local police station, since he knows the suspects, so that the matter can be investigated. Yes, that's how it went, my lord. And I said, should he have challenges or need further assistance, he can then advise me accordingly.
Do you know if the case, do you know if he eventually opened the case as per your advice?
No, I don't know that, my lord.
Mshololo also turned to the statement of Senzo Meyiwa's brother-in-law, Mnisi, who in his statement indicated that Meyiwa's friend, Tumelo Malala, told him that Senzo was shot by mistake while trying to break up a fight between Zandi and her then-boyfriend, Longwe Twala.
In your investigation, Brigadier, did you have any encounter with this witness, Mlungisi Edward Sope? Whether it's a meeting or whether it's a formal or informal meeting regarding this statement and the information contained there too?
So, my lord, the answer is yes, but perhaps let's start from here, my lord.
Okay.
The investigating team that was dealing with this matter, my lord, they found no basis back in 2015. So I'll start there and then move to my engagement with Mr. Sope.
Where is that? Where is that they found no basis?
You'll find in the diary, my lord, because it was investigated. Remember, it was before my time.
Okay, can I see that diary?
Well, I'll look for it, and then I'll refer you to it. But it was followed up, my lord, in short. Okay. Then second, my lord, fast-tracking to 2015, 2016, this is where now I referred and I testify about this, that I was sent by General Nkomo and then the Acting National Commissioner, General Patlane, to go and inform the family that they will be coming to them and give them updates insofar as the progress of the case at the time, but also to assist with whatever that we can do. Now, in that meeting with the family, because I was not the investigating officer, my lord, I did not have this docket, and I did not know that this statement that we just read now was in the docket, as I was not the IO, my lord. So the family brought it to attention when I went. I think we were about 9 members of the subs.
Sorry, when was that?
That was in 2016, my lord. We dealt with that aspect, I think, through...
Don't forget about dealing it before. Just tell me when was that?
Yeah, but what I'm saying is, my lord, I'm repeating what I've said before, because I placed the statement of Captain Mabuti to say, I think Mr. Ramsipele took me through when we went there, what were the circumstances. I dealt with it. So what I'm saying is, it is here. I'll also find it. It indicates, my statement is there. I was even asked, my lord, as to why did I make the statement. And I said, the DPP felt that because there were these allegations that there's a statement by Mr. Sope which was seemingly a breakthrough on the case, which was not filed by me, which was not true. we should then address that issue. Subsequent to that, my lord, then I had to make a statement. I dealt with that part. So I'm just going back to say I dealt with it under that context. So when we then went to the Meyiwa's family, my lord, this information from the family side was brought to attention to say, we don't understand why there's difficulty in solving this case, because our son-in-law, this is now Mr. Hlope, received this information from Mr. Malala that there were no intruders. The deceased was shot by mistake. We then asked to meet Mr. Hlope, and that is how now I came face to face with him. Not me alone, me with my colleagues. And then Captain Mabuti, in my presence, my lord, then obtained his statement, saying more or less the same things that have been said here. And I said, when that was followed up, under tremendous difficulty, I even indicated, my lord, previously, I was testifying here, I think under Mr. Ramsipile, that I had to go through Brigadier Modise, who was the investigating officer, because the witness then, Mr. Malala, was refusing to talk to me, saying, no, we don't know you, who are you? So we had to ask the Brigadier to allow us to convince him to talk to us in trying to establish this aspect. And eventually when he spoke to us, he refuted that aspect. And I moved further, my lord, and said, when then we have taken over this matter now, when I was identified, or rather given this matter to investigate as a lead investigating office, I also confronted him again on this aspect, and he refuted this aspect and said he never said it to Mr. Hlope. So that's the context that I dealt with this statement, my lord.
Mshololo turned to the cell phone downloads of the people in the house. Gininda tells the court that they were obtained in 2014, and he asked cell phone data analyst Colonel Steyn to authenticate them before analyzing them.
Again, there is no way Colonel Steyn could have authenticated the device, the information retrieved from the device belonging to Ms. Kelly, which linked the call which was made from the number belonging to accused number 5. Because he was not there when that cell phone belonging to Ms. Kelly was retrieved, when the information from the cell phone belonging to Ms. Kelly was retrieved, and he only received the data information which had been stored in his absentia.
My lord, I disagree. So perhaps one very quickly needs to look as to how download is done, because the download, my lord, is the mirror image of the cell phone. Secondly, when you authenticate, my lord, you look at the information, the data that you have in relation to what was downloaded by the police. They expect to have those expertise, my lord, because the data will indicate insofar as the email number of the downloads that were done on the phone, which will be read insofar as my experience tells me, my lord, which will be read to the cell phone data section 205, which will indicate the cell phone number and the email number of that gadget. So through their expertise, my lord, they will be able to say this data, it's indeed coming from the storage data of the ACPS and subsequently confirmed by the service providers if it's cell phone records, my lord.
Colonel Steyn revealed that there was communication between singer Kelly Khumalo, the then girlfriend of Senzo Meyiwa, and Fisokuhle Ntuli in August 2014 and in October, just days before the murder. This is among the links that the state has drawn between Kelly, who it believes is the mastermind of Meyiwa's murder, and the men charged with the crime. Fisokuhle Ntuli admitted that the number belongs to him, but denied ever communicating with the singer. He cited the records of Vodacom's Pinky Weithelingam, saying they do not show such a call. Weithelingam said the activity did not reflect as a call under their records, but internet data. After being recalled, Steyn said the calls were made via internet data.
Brigadier, is there any evidence of the transactions which were made between the cell phone number belonging to Ms. Kelly Khumalo and accused number 5 on the 26th of October 2014?
No, I don't think we have a call or communication between Ms. Kelly Khumalo and accused number 5 on the date of the incident. Was
there also any communication or transactions between Ms. Kelly Khumalo's number and accused number 5 after the incident?
Not the report. I don't have that report, my lord.
Proceedings did not resume on Tuesday after Mshololo requested for a break. In a devastating twist, the news of the passing of the lawyer for accused number 1, Thulani Mngomezulu, broke, opening the floodgates of tributes from the legal fraternity friends, and those who religiously followed the trial in court and on various media platforms.
I want to see the relevance.
Mngomezulu was first introduced to the case last year during the trial within a trial, assisting Sipho Ramosipili, who represented accused number 1 and 2. It was in March this year when accused number 1, Muzi Sibiya, decided to appoint him as his sole legal representative. Mngomezulu fell ill as the state inched closer to calling its last witness. This prompted him to ask other defense lawyers to stand in for him. He was last seen in court on the 8th of November when a decision was taken that he would now be following the proceedings virtually while keeping track of the witness testimonies on court transcripts. On Wednesday, proceedings resumed on a somber note as the judge asked that we observe a moment of silence in honor of Mngomezulu. This was followed by talks on what Muzi Sibiya would now have to do following the passing of his lawyer.
Mr. Sibiya apparently has chosen that he would wish to be legally represented through the sponsorship of the Legal Aid South Africa. Yes. Now the question is to identify a person that is going to proceed with this legal representation. So Legal Aid South Africa indicates that they would dearly appreciate it if it were to be one of the counsels that have already been involved in the matter here. That would simply obviate a lot of things, time for preparation and all those things, my lord. What is, however, still missing, it's the identity of that individual. So what we are looking at, my lord, is because Mr. Ramsipili is here, Mr. Khumalo is here, I'm here, and Advocate Msholole as well. I think amongst ourselves, we are saying we also need time to go and consider certain issues before each one of us can raise their hand and say, so we would definitely go and consider a few items on that point. So we are of the view that whilst we will be having our first day of the sitting in the new term next year on the 20th, specifically for this item, we could then reconvene tentatively on the 8th. We have a special sitting on the 8th to come and deal with this item.
His unfortunate passing comes just as he was about to start cross-examining the lead investigator, Brigadier Bongani Gininda, after it was postponed due to his ill health. Mngomezulu was laid to rest on Saturday in a fitting send-off. But what does that mean for the trial? Our legal analyst helps us unpack this after the break. Welcome back. The unfortunate passing of Thulani Mngomezulu leaves his client, Muzi Sibiya, with a decision to now choose a new lawyer. I spoke to legal analyst Kabelo Siabi about the implications of Mngomezulu's passing.
Having to grind to a halt due to the unfortunate passing of Thulani Mngomezulu, the lawyer of accused number 1, it's such an unfortunate situation, and when you look at it, it puts accused number 1 in a very difficult position of now having to choose a new lawyer. But talk to us about legally what happens when such a situation arises?
Hello, Linda. Linda, perhaps first of all, I must convey my personal condolences to the Mngomezulu family and also to the colleagues. Mr. Mngomezulu was an attorney, a fellow attorney, and he was one of our colleagues. And it's a sad loss to the profession that he has passed away. Now, the impact on the trial would be that once a representative passes away, the accused is afforded an opportunity to appoint alternative legal representative. In this instance, the accused would have three options. It's either the accused instructs a legal representative of their own choice, meaning that the accused chooses whoever they want, and the accused is responsible for paying the fees of that legal representative. The second choice would be that the accused applies for legal aid, and the legal aid board would then appoint a practitioner who is paid from the funds that are made available by the government to the legal aid board. The third option is that the accused can choose to represent himself in the trial and continue on their own without having a legal representative.
And we heard just before the matter was adjourned earlier this week that legal aid says it could finance him. And when one looks at his history with legal aid, previously that indicated that if he chooses to leave them initially, then it would affect his ability to get funding again, once he's appointed his own lawyer. And now they're coming back and they say, well, we can fund you, and perhaps it would be much better if you choose a lawyer amongst the defense lawyers that are already in this particular case. Unpack to us, how that could possibly be seen in various ways or interpreted in a way that maybe because they are funding him, they are now choosing a lawyer for him, which basically then may mean that he's not necessarily that involved in choosing his own legal representative. Just clarify for us, how this works.
The issue with the legal aid board is that the legal aid board, you would remember, initially when the accused opted to stop using the services of Mr. Ramosepile and opted for Mr. Mngomezulu, the legal aid board had indicated that if you terminate the funding the legal aid board is giving, the legal aid board will not in future cover you. But with the developments that have happened, the legal aid board appears to be prepared to take again take up the funding of the defense for the accused. Now, for practical reasons, it would be most practicable if one of the legal representatives that are already involved takes over the defense of the accused, because that legal representative will already carry the knowledge of what has transpired in the trial. If the legal aid board was to choose a different person, that different person would initially have to obtain the transcript of all the proceedings from the beginning of the trial. And we have already had at a discussion in court that the record spans over 40,000 pages. Now, it would mean an entirely new legal representative would have to read through those 40,000 pages, and that legal representative would obviously have to be paid for the time that it takes to read that 40,000 pages. Legal representatives, by the very nature of our work, we sell our time. So if I must read through that 40,000 pages, I would have to be paid for reading through the 40,000 pages. So the most practicable scenario.
But how would you bill for that? Help us understand when you're going through those records, how would you bill for it? Would it be based on the number of days you're spending or the time that you're spending on those records?
The billing will be based on the time it takes to read through the record. On average, you are given 20 pages for every hour. And you can imagine 40,000 pages, how much that would amount to. So it would be quite a substantial amount of money. And that's why I said for the Legal Aid Board, probably it would be very economic for them to get somebody who's already involved in the trial and who will not cost them the amount that would be needed to read through the entire record. For instance, if one of either Advocate Khumalo or Advocate Mshololo or Mr. Mnisi were to take over the matter, they would not per se require to read through the 40,000 pages. But if somebody like me was to step in, I will have to read those 40,000 pages and I would have to be paid for the 40,000 pages for the time of reading through the 40,000 pages.
I mean, if he says, well, I've heard what you're saying, but I'd like my own lawyer. Will this in any way impact legal aid's ability to fund him? Although, of course, like you say, their suggestion is on the cost implication of the decision that he has to make.
Obviously, the final decision lies with the accused person. It is the accused person who has got the right to choose who they want to represent them. And if the accused says that for one reason or the other, there is a conflict of interest with the present legal representatives, and it is undesirable that any of them take over his matter, then it would become inevitable that an entirely new legal representative should be appointed in the matter. And that person would then have to go through the process of preparing through the entire record.
So when the trial then continues, I mean, looking at, in fact, the judge said to them that in any case, some of the defense lawyers were cross-examining, not necessarily confined to their own clients, but they were cross-examining, looking at all the accused and what this basically rebutting the state's evidence for all the accused. Do you think it's still ideal that he chooses a lawyer that is amongst those that are already in court?
The legal representative that appears on behalf of an accused person has to be instructed specifically by that accused person, so that the legal representative, when he puts any statement in court, that statement must be based on the instruction given by the accused person that he is representing. So it is not going to be a case that questions have been covered by other legal representatives. Every accused person is entitled to their own legal representation, and every accused will then give specific instructions to their own legal representative, and that legal representative has to conduct the case and to make statements that emanate from the instructions that are given by an accused person.
The decision that accused number one, Muzisibia, has to make is a big one and could impact other accused persons. If he decides to choose if he chooses his own lawyer outside of, the ones that have already been suggested, what do you think the recourse should be, or will be for those who are already on trial who perhaps want this matter to go forward? If other accused persons say, we don't want any further delays, this matter has gone on for quite long, what is the recourse for them? Can they apply for a separation of trial, and how would that impact on the overall case?
Yes, it is always possible where you have more than one accused person that one of the accused person can apply for a separation of trial. But when that application it is made, the court has to consider the advantages of separating and the disadvantages of separating the trials. In this particular instance, this trial has endured for a very long time, and there was a long process of trials within a trial. There was a long process of cross-examination of various accused persons, and at the stage where the trial is, it may be very undesirable that there be separation because the trial has progressed to a very high degree at this stage. We are almost at the tail end of the state's case or the prosecution's case. So it might not be very desirable to separate the trials. And for that reason, the court may adjourn the matter to allow the new legal representative to become or to familiarize themselves with the proceedings and to take up where the matter presently stands.
But then how does the court then guard against any prejudices against the other accused? Because it's also not their fault, and it's no one's fault really, that an unfortunate situation like this has occurred.
The question here becomes that there must be struck a balance. You must remember that because the accused are in the same trial, the court has to strike a balance between the interests of each of the 5 accused, but at the very same time also take on board the interest of the prosecution. So it would be an act of trying to balance all those interests and finding the middle ground that covers all their interests, or that is the most acceptable position for all the parties involved.
And I just want us to touch quickly on the evidence against accused number 5. What has been your overall impression? I mean, there's been talks about the car possibly being a hired car, but there's also been talks about the meeting at the hostel. Quite important. I see, all the lawyers are touching on that particular, evidence, particularly where Zungu is concerned. But there's also the issue of the cell phones. You'd recall that the state is alleging that at some point, all the accused were in communication with accused number 5, who they believe is the one that got everybody together. So overall, when you're looking at the evidence that is against accused number 5, what are your thoughts so far?
The state's case against accused number 5 is primarily one that is more of a circumstantial case, in a sense that the state has placed evidence that puts him at a place where there was a meeting before the crime. He is being placed also within the locality where the crime occurred in the company of the other accused persons. And then there is that linkage with the cell phone. So the case against him is circumstantial in that sense. You must remember that when the court evaluates evidence against an accused person, the court is entitled to look at the totality of the evidence and, where practical, to also draw what we call inferences. If the court draws the inference that he was a participant from all the available evidence, he can be convicted based on the inferences that are drawn that says that he was a participant in the commission of the offense.
There was legal analyst Kabelo Siabi unpacking what the passing of Thulani Mngomezulu means for the trial and also the cross-examination of Brigadier Bongani Gininda on the evidence the state brought against accused number 5, Fisoguhle Ntuli. Now remember, court is officially on recess and will only return next year for a special sitting on the 8th of January 2025. This is just for Muzi Sibia to confirm the appointment of his legal representation. The main trial, however, will only resume on the 20th of January. But you and I will keep the conversation going this December about the evidence we have heard so far. Until the next one, bye-bye.